I'm so sorry. I'm sorry. Please. I'm so sorry. I'm so sorry for what they lost.
So she's going to be going into custody today. Ms. Guerrero, she'll be remanded without bond. If
A woman appeared in court today for breaking the rules of her probation. She got behind the wheel even though the court had clearly told her not to drive. She's now facing a serious charge: vehicle manslaughter. That means someone lost their life because of a poor decision she made while not in a safe condition to drive. It's hard not to feel the weight of what happened, especially for the family of the person who passed away. You'd expect that someone in her position would be extremely cautious, but sadly, that wasn't the case. How long do you think is fair in a situation like this? It's a tough question, but let's take a closer look at what happened.
and we have an issue with your client, Ms. Guerrero. Your client was driving and vaping, and she's charged with intoxication manslaughter. I don't know what the conditions are, but she may not be leaving the courtroom today.
Okay.
It depends on what her conditions are.
Okay. Is there any way to set her up on a computer right now to talk to me in private?
Yes.
So I can find out what's going on?
The court has discovered from reviewing the filings. Yes, a motion was filed where this defendant was allowed to have the remote in-home monitor installed in the ignition interlock with an affidavit of non-driving. So she's not supposed to be driving because she's using the in-home. So what she has done is she's violated her conditions of bond. So she's driving and she's supposed to have, she's not supposed to be driving.
Okay. As far as I understand, I asked her about having a valid driver's license. I didn't ask her about the difference between the ignition interlock and the home handheld device. I'm sure that she would be more than amenable to have that ignition interlock placed on her vehicle. I do understand that there was an accident and her vehicle was not working, but maybe she has a new vehicle. I didn't get all those details, Your Honor.
All right, so that's what the court has, and that was dated on September 8, 2020. And the court doesn't have an order that's saying that she's going to be driving with ignition interlock. In my understanding, she doesn't have ignition interlock on her vehicle, and she should.
Okay.
So she's going to be going into custody today. She violated her conditions of bond. I can't have someone. And Ms. Smith, I don't take it as true that you committed an intoxication manslaughter, but you're charged with intoxication manslaughter. And one of your conditions was because your previous attorney came to me and informed me that you would not be driving. And so I allowed you to have the in-home monitoring device installed in lieu of ignition interlock if an affidavit of non-driving was provided. So you're driving and you don't have an ignition interlock. That's a problem. So you're going to be taken into custody today. Ms. Guerrero, she'll be remanded without bond. If you want to file a motion to have the court reconsider that or bring some more information to me, Ms. Guerrero, of course, the court will be more than willing to consider that. But for now, she is, I'm issuing a judge's warrant and she's going to be remanded.
Okay. Well, I'll visit with her tomorrow through the jail and I'll report back. Thank you, Judge.
All right. Thank you.
If you're not familiar, vehicle manslaughter is when someone causes another person's death through dangerous or impaired driving. It's one of the more serious driving-related charges, and it can lead to many years in prison. What makes this case even more troubling is that she went out driving again even after the court told her not to. When someone is on probation for something this serious, you'd expect strict compliance with the rules, but clearly that didn't happen. Fast forward a year, and something about her seems very different. Whether it's due to stress, health issues, or something else, there's a noticeable change. What do you think led to this shift?
And are you Ms. Smith?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes,
The court will find that the state is in compliance with discovery. Ms. Smith, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on the count 2 charge of manslaughter and waiving counts 1, 3, and 4.
No objection.
All right, Ms. Smith, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with the offense of manslaughter? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
May I clarify one of my responses in response to your question about motions?
Yes.
I said that I hadn't filed any, and I'm not sure if Ms. Corley did, so I don't want to represent to the court because I think she may have filed some evidentiary motions. I did file some non-evidentiary motions, but I wanted to make sure that if Ms. Corley did, I didn't represent that there were none filed.
All right. And I can tell you from my review of the court's docket sheet that there was no motions that were heard.
Okay.
And there were some motions that were filed, but none that were heard.
I just didn't want to make any misrepresentation.
All right. So the court is finding you guilty of count 2. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
On behalf of my client, Judge, this is a case that was a tribal type case based upon the evidence that you reviewed. My client has made the decision to come in and accept responsibility for her portion in this accident that happened. She's extremely remorseful. She wants to get this behind her and she wanted to say her apologies to the family that the area where this happened, the location was very dark and she just didn't see that there was an accident in front of her. She has Graves' disease and she's been pretty ill at the jail. So she's hoping that this time will pass and hopefully that she can get her life back together. She was a home health care provider and she did help a lot of people while she was out in the field.
All right. Anything from the state?
And we have victim impact.
All right. Anything you wish to say, Ms. Smith?
I'm sorry, please. I'm so sorry. I'm so sorry for what they lost.
All right. Anything else from either side?
No, Your Honor.
All right. I'm going to follow your agreement. I'm going to sentence you to 6 years in the prison and give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right. We can go off the record. So, Ms. Smith, there's going to be a victim impact statement. What I can tell you is I know that sometimes emotions and tempers run high. Because in this court, we'll deal, as your counsel will tell you, and the state will tell you, we're dealing with serious cases, major felonies. But I do require that everyone treats everybody with respect and kindness. So there are some persons who want to say something to you. Just listen, internalize.
A 6-year prison sentence was handed down for the charge of vehicle manslaughter. While not all the details of the case are public, it's clear that the consequences of her actions were devastating. She claimed the area was dark and hard to see, but the facts suggest she wasn't in a proper condition to drive. It's difficult to know whether her apology came from true remorse or the reality of prison time setting in. What's certain is that this incident changed lives forever. It serves as a serious reminder. When you're on the road, your decisions affect more than just you. What's your take on this sentence? Was it fair, too light, or too heavy? Let us know in the comments, and if you find real-life courtroom stories like this important or thought-provoking, consider subscribing for more updates like this. Your support helps keep the spotlight on cases that matter.